Hello there, I'm Sean Spaulding, North County's tax and estate planning attorney. I created this quick presentation to inform viewers of an all-too-common estate planning oversight. Specifically, we look at the step-parent-stepchild relationship and how it may lead to the inadvertent disinheritance of your children. Please feel free to leave questions and comments after viewing this presentation. Thank you. Okay, the issue we are exploring today relates to California as a community property state and how the intestacy laws combined can lead to the inadvertent disinheritance of your child from a previous relationship. You may be wondering, what does community property really mean? Generally speaking, community property is all property acquired while married and living together. Limited exceptions may apply. That means wages earned, investment income, and other property purchased by the couple is considered community property. Again, there are some exceptions, but for the purpose of this presentation, we will mostly assume everything is community property. Now, I threw out another word you may be wondering about, intestacy. A person is considered intestate when they pass without a will and they owned probate property, such as real estate. Furthermore, the intestacy laws lay out how your probate property will be distributed to your family members. This is where the community property laws and probate code meet. If you only owned community property and died intestate, then all of your interest in the community property passes to your spouse. Let's jump to an example to illustrate the negative effects this may have on your children from a previous relationship. Anne married young and had one child by the name of Bob with her ex-husband. A few years later, after Bob was born, the couple divorced. Then, 3 years down the road, Anne remarried to a man that had a daughter by the name of Kim. Tragically, Anne was involved in a car accident that ultimately took her life. Unfortunately, she passed away intestate, and all the money she had saved from her job now transfers to her surviving spouse. Furthermore, Bob goes on to live with his biological father, and the stepfather's connection with Bob dissipates over the years. When the stepfather dies, he leaves everything to his daughter, Kim. It is unlikely that Anne intended for her son Bob to receive nothing when she passed away. However, because her intentions were not memorialized in a will or trust, the intestacy laws constructively disinherit Bob. There is one other common situation that occurs, which has the identical effect. Now, imagine a divorce and remarriage later in life, for example, after all the children have grown and moved out. Here, you can see how there are competing interests between the step-siblings and the first parent to pass away. Again, in this case, the step-parent is unlikely to establish a mother or father-type relationship with the stepchild because they have already grown and moved out. In these situations, it is an especially good idea to properly plan the distribution of your property. Otherwise, you could leave a loved one completely out of their inheritance. Again, thank you for taking the time to watch this presentation. If you have any questions or remarks, please feel free to write them down in the comments section below. Remember, this presentation is not a substitute for sitting down with an attorney. Adequate legal advice requires a detailed analysis of the specific facts of your situation. I am happy to discuss your estate planning needs at no cost.